In today's discussion, we shall be talking on legal liability as it concerns community health practice. Okay, but we shall take it step by step until we arrive solely to the end of the lecture. Everyone is entitled by law to the reasonable enjoyment of life, liberty, property, and security of his person, his family, and his possession. This entitlement is covered by law, and no one has a right to breach it. Government recognizes these rights and protects them. Okay, government recognizes these rights and protect them. Okay, although the government also may properly impose certain desirable restraint upon individual rights for the benefit of the common good. This usually comes into play when there is needs or emergency. That's why when we say this health there is an emergency health condition, or they have declared coronavirus a health emergency. At this point, it actually means that some laws that's already existing. That's why when there's emergency, laws are not followed strictly, because government is given powers to override the fundamental laws or the human rights. So that is why before, if you can recall, before there was imposition of lockdown and other restrictions, it was first declared a health emergency. And at that point, once it's declared a health emergency, the governments are now given much powers to take decisions in order to solve that problem. As such, it's some of the rights of the citizens are breached. Okay, so we say that government recognize this right and protect them, but the government can also restrain this right during health emergencies, and that is when we begin to talk about legislations. Maybe laws are passed for them to curtail or solve that health emergency. At that point, like we saw in 2020, there was lockdown. Lockdown is against human rights, civil rights, okay, because people are entitled to movement, okay, and to liberty, like we said, liberty and all that. So, but during that lockdown, it was restrained due to it was an emergency, and there was need to control that emergency. Okay, so the state always regulate life, liberty, and property in the interest of the public health and the general welfare. Now let's look at the torts. We say that torts are civil wrongs made against a person or property, and we only talk about these torts when individual rights or person's rights is violated. Okay, we have talked about the government, how they can do that during health emergencies. Okay, but ordinarily, when a person's rights is violated, it is known as the tort. Okay, we call it the resulting wrong to the individual. It's called a tort. Okay, we have numerous kinds of torts, and many may lead to hazard to human life. Some also lead to injuries to personal health. Now we say torts are civil wrong made against a person or property. A tort can be any of the following. So tort only results when any of this following happens. One, when you deny a person's legal rights, and when the government denies someone his legal rights, we say that there is tort. Okay, it's an individual, it's a wrong made to an individual. Then failure to comply with public duty. That's what is called public duty. You owe that public duty to the government. Okay, so the failure to comply with a public duty leads to torts. Then the failure to perform a private duty that results in harm to another is known as tort. So this last component of the tort is what we are interested in, because that is what leads to legal liability. Okay, we said that torts are civil wrongs made against a person and can occur in the following ways: the denial of a person's legal rights, the failure to comply with public duty, and finally the failure to perform a private duty that results in harm to another. In line with this, healthcare providers and people who sell products and services to people may be sued when there is error. Like we said, when an individual fails to perform his private duty to an individual, which leads to injury to him or her, it leads to tort. Okay, and when can this happen? Because we say this is the component that involves all the healthcare workers, community health workers. You as a healthcare practitioner, before you possess that license, it is expected that you have passed through the required institutions and licensed according to the law. Recall in our previous classes I said that before you are given that license to practice, it is assumed that you have acquired the necessary knowledge, skills, and experience as stated in the administrative law of that agency, that government agency. The Community Health Practitioner Accreditation Board of Nigeria is a government agency which has an enabling act, a law that empowers its operation. So before they give you that license, they have assumed that you have acquired that knowledge. That is why there is professional examination. So by virtue, it actually means that you are offering people services in a professional capacity. Okay, so but for any other reason there is breach to this, then it can be considered as a tort, especially when it leads to injury to the person involved. We say any person who offers his services in a professional capacity, whether as a physician or other healthcare workers, have a contract with his employer. Okay, you're having a contract with the employer because that patient is employing your service. You technically have a contract with that person, and in that contract you are telling that person that you possess the reasonable degree of learning, skills, and experience usually possessed by members of your profession. You are giving the person this assurance that you have all this. You're also assuring the person that you will employ reasonable and ordinary care and diligence in the exercise of that skill, knowledge, according to your best judgment. So this is a contract you have created for the fact you say you are a registered community extension worker, a community practitioner, that patients should come to you, you will treat them. You are actually giving them this benefit of that you have the learning, skills, and experience, and that you will employ reasonably and ordinary care and diligence in the exercise of that skill and knowledge according to your best judgment. That is what you are telling that patient or that employer who has that contract with. So as you have given this person this belief, if then there's any reason you do not meet up with that expectation, it can now be said to be a negligence. Okay, and you are now liable. You see, so injuries now which may result because the person already trusted you based on that, okay, that you are to provide quality care, and that's why the person will come and submit his or herself to you freely to carry out this care, because there's a belief and there's this legal trust on it. So injuries resulting from failure to do the things expected from you as an average health worker makes the practitioner or makes you liable. You have then you have the skills, you have the knowledge, you have the experience, and that you use your best judgment. Now, in the process of the care, you are not even able to do what an average committed practitioner should do, then you are liable for negligence. Take for instance, it's expected of us as committed workers that when you see difficult cases, you should refer, but you fail to refer. Ordinarily, an average committed worker will supposed to refer, knowing that this condition is beyond his scope, or at least maybe you are expected to use only auto disable syringe for single use. You use it and or use it again. That's minimum sum that's expected of you, and you could not meet up with this. At that point, if it results to injury, it is known as negligence and you are liable. Okay, so now this is under the third component of tort, where we said when you have failed to perform your private duty as legally indicated, then the tort comes to play. And we say that these torts provide a system for compensation of an individual who is already injured or whose rights have been trampled upon. Okay, so the tort system provides compensation for persons who are injured through the negligence, or it might not really be negligence, it can also be as a result of your intentional actions. You willfully decided not to do this. Okay, who has a legal duty to avoid such injury. So it provides a compensation for persons who are injured through the negligent or intentional actions of others who have legal duty to avoid such injuries. Now, if the patient who have incurred that injury wants to seek for compensation, he can actually achieve that through malpractice suits. This compensation is usually achieved through malpractice lawsuits, and which is often the first heard in the tribunal set up by the Registration Council of the professional group. Now, the professional group will always have a tribunal that will be set up who will look into the case first. This tribunal has members with the requisite professional qualification. They have the requisite professional qualification and experience. They have the required knowledge and professional qualification and experience, and is thus in the best position to determine whether that act allegedly committed is unprofessional or below the acceptable standard. So they are in the right position to determine this. These tribunals will base their judgments based on the laid down rules or according to the enabling law of that professional body. Like in community health, the rule number 15, which says the community health practitioner and the legal liability, says that any person who commits an act contrary to the laid down rules of the profession, because there's already a rules that are given, use your standing orders, carry out patient's assessment using diagnostic skills and your professional skills, referral system, and all that rules. So if you fail any of the rules contrary to the laid down rules of the profession, must face the punishment commensurate to the offense of his or her actions, or compensate the aggrieved party. Now next says, for a community health practitioner to be liable for an act, the following must be established. They are the members of that tribunal will now be the people to ensure any of these have been established. Most of these have been established. 1. The health practitioner must have acted illegally and not have been in a state of unconsciousness, like be in a state of sleepwalking. Okay, like the person is conscious, that is, he is conscious, then the act may be omission or commission. The act can be negligence or intentional. Now, secondly, it must be proven that it was the health worker's conduct that caused the harmful consequences, okay, like a cross infection in a health facility. Thirdly, the conduct must be wrongful and unlawful and therefore unreasonable in the eyes of the society. Remember, you have told them that you have the required skills, knowledge, when you say you can provide that skill. So when you cannot provide, it's now unreasonable. Then the conduct, okay, the next is intentions and negligence must be clearly established. Then there must be damages or prejudice resulting from the act. And finally, he must have made wrong assessment of the patient without using the standing orders. So, for that tribunal set up by that professional body for community health to say, yes, you are legally liable for this act, that act must have met with these conditions, and based on this, they will not say you are legally liable, and so far you have to compensate the patient. Okay, so any negligence and or violence of any of the above codes of conduct shall be reported to the disciplinary committee by either a fellow practitioner or any member of the public, and upon any report the investigation panel will carry out, that this tribunal, its function as assigned to it in section 21 subsection 3 ABC of Act degree 61 of 1992, based on the directive of the disciplinary committee. After the necessary investigations, finally, it is important and encouraging for you to always follow the rules of the profession, because these are enabling laws and it has a legal backup. Because of a huge amount usually paid out to the aggrieved patient, it is good you follow the directives of the standing orders. This will protect you in the event of any litigation or any suit, should in case the patient should die. Because the standing orders is your legal backup. It is the only legal protection you have. Because in the rural community, you might not be opportune to carry out every medical test or diagnostic procedure required at primary level, maybe due to limited resources. But with the use of standing order, it is believed you have done the best that's expected of you within that area of primary health care.